Wisconsin, Mr. Sensenbrenner, for 5 minutes.
Thank you very much, Mr. Chairman. Mr. Koskinen, first of all, thank you for coming here. I think that you have been able to present your side of the story in a very articulate manner in response to both friendly and hostile questions. I want to make an observation before asking a couple of questions. This administration has made a career, or maybe history, of basically ignoring whatever Congress wants to do in furtherance of its constitutional oversight responsibility. That includes blowing off subpoenas, delaying things, not having full disclosures, covering things up. And in the case of Lois Lerner, who was cited for contempt, the U.S. Attorney announced that he would not present the contempt citation of a separate, coordinate, and co-equal branch of the government to the U.S. District Court for the District of Columbia 30 minutes before he left office following resignation. That, in my opinion, is an impeachable offense. But since he left office 30 minutes after he committed the offense, there was nothing that Congress could do. You know, I think we have to look at ourselves. One of the things I think we should do is to allow the counsel for the clerk of the House to be able to go directly into U.S. District Court to enforce congressional subpoenas and, you know, other types of process to support our constitutional oversight responsibility. And I think a lot of the problems that we've had, not just with you and with the IRS, but with a lot of the other agencies would be resolved if we could go directly into court rather than having to go through the roadblock of the Justice Department. Now, that being said, I am very curious on how Lois Lerner, who is a member of the Senior Executive Service and who developed a reputation as a partisan when she was working for the Federal Election Commission, ended up getting to the IRS and being put in the position that she was in. Now, I know this happened before your time, and I know you probably don't know why, but could you tell me, you know, what the process is of transferring SES personnel from one agency to another agency, and who initiates that and who signs off on that, you know, aside from the member of the SES who is proposed to be transferred?
Right. You're right. I have no idea how that happened when she arrived. As a general matter, at least at the IRS, I can tell you that. We will, if we have an opening, we will, an SES opening, we will advertise it publicly. And it will be open to both government executives within the IRS and across the government, and private sector executives who will then have to qualify, determine that they meet the SS requirements. When they apply, there is a preliminary screening of all the applications by a panel. There's a separate group of senior executives that then interview the finalists and make a recommendation then to the commissioner on the basis of that review. That second panel is, these are all career employees. The only political appointee at the agency is the commissioner and the chief counsel. That recommendation goes to, in our case right now, that group are the two deputy commissioners and the chief of staff to the commissioner. They interview then the 3 or 4 final candidates, and the recommendation comes to the commissioner.
Let me say, I don't think it was a coincidence that Lois Lerner left where she was from at the FEC and ended up where she went to in the IRS. You know, there had to be some kind of political design involved in that, and I think Congress should look into whether there are political transfers. You know, the other thing, I'm proud of the fact that I'm conservative, and I know you're not. But I think that one of the things that all of us who work for the government are supposed to do is to engender and increase public trust of government institutions, which isn't going very well now. Now, put yourself in my shoes, you know, somebody who represents 715,000 people in Wisconsin. How do I tell my conservative constituents that they should increase their trust in the IRS and that what happened to a couple of my groups will never, ever happen again? Thank you.
I think what you could tell them is there have been 6 different investigations. The Internal Revenue Service has taken every recommendation they have control over and implemented it. The IG has reviewed The implementation of the IG's recommendation has said we've done substantial progress, made additional recommendations for additional training before elections, which we have taken, that we have created a risk management operation and organization in the agency where I've now talked to 22,000 IRS employees in person in town halls, and one of my pitches to them is everyone has to be a risk manager. Everyone has to raise their hand if they think anything is not going the way it should, if there's a mistake or a problem, so that we can deal with it. And I think you tell them we are committed, and I am personally committed, that that situation was intolerable and should never happen again. As I said, you should be able to tell your constituents with a straight face that we will still do, even with constrained audits and resources, over 1 million audits this year. And I think the system won't work if people, when they hear from us, think that, wonder who I talked to the wrong way. Did I go to the wrong meeting? Does anybody know that I belong to this organization? People should be comfortable that the IRS process does not care who they are in person, what their political beliefs are, what organization they belong to, who they voted for. If they hear from us, it's because of something in either their application or their return, and if somebody else had that same question, subject to resources, they would hear from us as well. The system will not work unless we can get taxpayers to understand that. And I understand, the reason I took this job was because I understand that the mistakes that were made, the intolerable operations, were corrosive to public confidence in the agency. We touch virtually every American. 150 million individual taxpayers file with us. They need to be confident that they're going to be treated fairly no matter who they are. And I'm committed to that. And your constituents have to know we're committed. The proof ultimately will be in the pudding. People have to see in our activities that we, in fact, treat everyone the same way. They're all treated fairly. That's our obligation.
Thank you.
Chair, I recognize the gentleman from Florida, Mr. DeSantis, for 5 minutes.
Commissioner, when does your term of office expire?
My term expires, I think it's November either 9th or 12th next year.
Of 2017?
Yes. I've made it clear I serve at the president, even with a fixed term, I serve at the pleasure of the president. So whoever the new president is can decide to make a change if they'd like.
So you will offer a resignation, whoever comes in, and you'll offer to step aside?
I know I have a fixed term, so unless I actually don't want to fill out my term, I serve at the pleasure.
I understand that, but when you say you serve at the pleasure, meaning that if the president came to you and asked you to step aside, you would.
I would.
If you got fired, but you're not going to offer to step aside unilaterally, correct?
That's correct.
Okay. Now, there's been talk about due process, but I just want to, for the record, we did have a hearing in this committee, I think it was in July, and you were invited to come to that first hearing, correct? And you chose not to?
Sure. No, as I explained to the chairman, I had just come back from abroad, and I had a hearing the next day. I explained to the chairman I would be delighted to come anytime, and I've been delighted on relatively short notice to be here today.
Okay. Now, I want to look at your testimony today because there's been a lot of talk, I think justifiable, about some of the things you've said over the course of the investigation that later turned out to be false. Now, today you testified that the IRS ended the use of BOLO lists more than 3 years ago. That's your testimony, correct?
That's my testimony.
Well, how does that square with the D.C. Circuit opinion where the IRS made that exact same argument and the court rejected that? They said, no, you have not ceased the conduct. You have chosen to suspend the use of BOLO lists, which means that you're free to attend, you're free to return to the offending conduct. And that's what the court found. So for you to say you ended the lists when, in fact, you suspended them, that's not just me being nitpicky. That is a distinction that the court seized upon and justified in its ruling against the IRS. Shouldn't you have said that you've suspended the use of BOLO lists?
No, that's Justice Department has the litigation, and that was what they provided. The IG reviewed this matter over 1.5 years ago and agreed that we had terminated. I wrote a letter to all the oversight committees saying it's been clear, however you call it, terminated, suspended, ever.
Well, it matters legally because if you're suspending it to try to get through a case and then you could return to it, the court thought that that was important.
Yes,
so there's no document, though, that says you've ended, or does it say you suspended it?
It ends, and I will be happy to share with the committee the instructions given to all people in the exempt organization decision with regard to this matter, and those instructions went out 3 years ago, and we'll share that with you. The other point...
The court rejected that. I mean, you agree with that. The court rejected that. The court found that the IRS has simply suspended the use of BOLO lists, but that you guys have not proven to the court, which that would have been the time to do it, that you will not return to the offending ways subsequent to the litigation?
Well, I can't speak for the Justice Department would handle the litigation. All I can tell you is we have provided all of the oversight committees with the note that we have committed and have terminated the use of BOLO lists. The question about the 3 that were pending, for 50 years, if you are involved with us and then you suddenly go to court, we don't continue to process the audit or the return.
But the court rejected that argument, as Mr. Jordan said. To be fair, the court said that puts people in a catch-22 because you tell them, you're going to violate their rights, and then if they seek litigation to get their rights, then you say, well, we're going to continue to violate your rights until the case is over. And the court thought that was unacceptable, and I do too. But let me move on. You have admitted that the subpoenas that were issued for learners' emails, that the IRS did not comply because there were tapes that were destroyed, correct?
That's correct. I mean, if we did not, we're supposed to produce evidence, we could only produce the evidence we have.
And I think that you've acknowledged that your June 20th, 2014 testimony, you did testify falsely because you said, quote, everything has been preserved, nothing has been destroyed. And of course, as we've established in March, just a few months before that, there were tapes that were destroyed containing pertinent emails. You also testified that day that you, quote, that the IRS confirmed that backup tapes no longer existed. I remember that exchange because I was sitting there. They drilled down to you. What does it mean by confirmed? And you said, man, somebody went and checked. And of course, that wasn't true because although the IRS had destroyed 422 backup tapes, the IG did find backup tapes that were still in existence at the time you made the statement. You also testified at your confirmation hearings that you believed in transparency and report problems as soon as you knew about them regarding the learner production, but you've acknowledged today that you waited 2 months and that was a mistake. One of the other things you said was that the IRS went to, quote, great lengths in order to provide Congress with the material that it requested. You remember making that statement?
I do.
Is that false? Did you go to great lengths to provide it? And here's why I ask that. Nobody in your organization ever went to the Martinsburg, West Virginia warehouse where they had the backup tapes. I put it on Google Maps today. It's about 76 miles from the District of Columbia. You've complained about how costly it's been to provide information to Congress in the past, but in fact, that would have taken probably a tank of gas to get there and back. And yet the Inspector General, when they went there, even though you said you went to great lengths, nobody from your organization had ever gone to retrieve any backup tapes. Isn't that true?
We went to great lengths to respond to the congressional request.
But those great lengths did not involve getting in a car, driving 76 miles, asking for the backup tapes, and then bringing them to Congress. That was a bridge too far for you. So I'm almost out of time. Let me just end with this.
Okay.
There's been disputes about did he order the tapes destroyed or whatever? I don't think that that's even the standard. Obviously, if you did that, that's a no-brainer. But I believe Justice Story was right when he talked about impeachable offenses being political offenses that grow out of personal misconduct or gross neglect. And he said they must be examined upon very broad and comprehensive principles of public policy and duty. I think that the IRS had a duty to provide Congress the information. The IRS breached the duty. I think you had a duty to display candor in front of Congress. I think your false statements, although you can say you didn't intend them, I think had you investigated more, you would have known. So I think it's really about breach of duty and about the gross negligence that's at issue here. I'm out of time, and I yield back.
The chair recognizes the gentleman from Texas, Mr. Ratcliffe, for 5 minutes.
Thank you, Mr. Chairman. Commissioner Koskinen, I've listened to you today. I want to make sure that I'm summarizing the testimony that I've heard from you and the things that I've heard you say today. I think you've been candid in some of your testimony today, but I want to make sure I'm summarizing what's happened on your watch as the Commissioner of the IRS for the last 2 years and 9 months. So I think you've acknowledged that there have been some failures by the IRS under your watch with respect to the retention and preservation of documents, correct?
That's correct.
And I think you've acknowledged that there have been failures by the IRS under your watch with respect to the production of documents and other evidence, correct?
No, we've produced all the documents. Our failure was, in fact, with the documents that we did not have. But we've produced, as I say, 1,300,000 documents.
Well, you've acknowledged failures by the IRS to testify accurately under oath, specifically yourself on a number of occasions, correct?
That's correct.
So in
But I
light of
did
all that,
testify on the basis of what I knew, but it was not, it turned out not to be accurate.
there's a difference between testifying truthfully and testifying to the best of your knowledge, correct?
No, actually, truthfully is what you know. Truth is, if I had known it and hadn't testified about it, that would be a lie. That would be untruthful.
Well,
At the time, I testified, I've had over close to 40 hearings.
Let me
I have always.
reclaim my time here.
I've
If you
I've
told
never,
the OGR committee that you would produce all of Lois Lerner's subpoenaed emails, that wasn't true.
no, actually, we produced all the emails we had. As I said
That's
at
not
that
what,
hearing.
that wasn't my question.
No,
You
at
didn't
the
produce
hearing.
all of her emails, did you?
No, at that hearing, we had a discussion about the fact that I can't produce emails that I don't have.
And on June 20th, when you said the IRS had preserved every email, that wasn't true.
That was actually, I did not know it, but that was not accurate.
Not true. And of course, as Congressman Gowdy asked you, when you said nothing had been lost or destroyed, that was not true.
That's right. It was, I thought
So
it was
in
true
light
at
of
the
all
time.
that-
Pardon?
In light of those failures to retain documents, preserve documents, testify accurately, I would hope that you would appreciate why it's legitimate for folks to wonder if they should take you at your word that the erasing of the tapes and the destruction of evidence was accidental, as you've characterized it.
You don't have to take my word. That was the Inspector General's results after a year of investigation.
Well, yeah, let me stop you there, because you've talked about that, about how the Department of Justice and how the IG have investigated that and how they've backed you up with respect to it being accidental. But the bad news for you, Commissioner, is that being cleared by the Department of Justice in this administration, unfortunately, doesn't carry much weight with the American people anymore, not since the Attorney General started handing out get-out-of-jail-free cards to Obama administration officials like most of us hand out candy on Halloween. But at least while we're on the subject, let me ask you this question. In the days before that investigation was closed by the Department of Justice, you didn't happen to have a clandestine but accidental meeting with the Attorney General on a plane or a tarmac somewhere, did you?
Never.
Okay, well, I hope you can appreciate why I'd asked that, because there's certainly a precedent for that type of thing happening. Regardless of whether this was accidental, let me concede to you, or for purposes of your answer, that this was accidental. It seems to me, based on what I've heard from your testimony today, that you don't think there should be consequences as a result of that. You know, for ordinary Americans, even if it's an accident, let's say someone gets in a car accident, if someone dies because of it, there are consequences. Now, someone might get charged with manslaughter, they might get charged with vehicular homicide, they might get charged, or they might be sued civilly for gross negligence or negligence. The consequences may be criminal, they may be civil, but there will be consequences. And that's the way our justice system is set up. But for you and the folks in the IRS, it seems to me that you want a different system and a different set of rules, where you can say, was an accident, I'm sorry, just move on. And to that point, let me ask you, since you took office to restore confidence and, in your words, provide accountability, and spent nearly $20 million to do just that, who's been held accountable at the IRS?
As I noted, the basic issue has been the management mistakes made in terms of identifying people for review just on their names, and all of those people are gone. With regard to...
Hold on, we're talking about two different things here.
No, now we're talking about since I've been there.
I want to talk about, yeah, on your watch.
Can I explain that? Okay. I will tell you, on my watch, we have ended the BOLA list. There's no evidence we're targeting any new organizations. We do have 3 that we suspended. We're now going to process, although one is sued for an injunction to keep us from processing. But I would note, in terms of the overall record, the IG spent a year and looking at tapes, found 1,000 emails. We produced 1,300,000 pages. So that...
That's not my question. My question is, who's been held accountable? So you mentioned that you had 50 people advising you on your watch. During your watch, which you've acknowledged there were failures to preserve, failures to retain, failures to testify truthfully. Have any of those folks been terminated? Has anyone been terminated on your watch for those transgressions?
No one has made a transgression that I think is a fireable offense.
Has anyone been demoted?
I'm not
demoted.
Oh,
I think you are. I'm not asking for their names. Has anyone been demoted?
I know a few have left.
That's not my question.
No,
Has
nobody's
anyone
been
been
demoted.
held accountable? And the answer is no.
I think that's probably right, because we don't think that anybody consciously or purposely did anything to interfere with the investigation.
Well, we'll just have to disagree on that. My time's expired. I'll yield back.
The chair recognizes the gentleman from Colorado, Mr. Buck, for 5 minutes.
Thank you, Mr. Chairman. Commissioner, welcome. You've been here for 3.5 hours now. The lights are hot, and I noticed that you've gone through your water. Do you
I got
need
another half a bottle left, so I'm all right.
okay, okay, good, because I've heard about dehydration affecting people's judgment. I want to make sure you weren't dehydrated today.
Thank you.
Okay, and you don't have pneumonia?
No.
Okay, good. I want to make sure. There's been a lot of talk from the other side of the aisle about due process, and I want to make sure that we have the same understanding of due process. You went to a great law school. You worked for a great law firm. You are well versed in the law and understand due process. And I was a federal prosecutor. I worked with special agents from the IRS. When they presented a case to me for charging, I didn't have to talk to the defendant. I didn't have to re-interview the witnesses. The level of due process in a charging decision is simply the person charging making a best effort to determine whether there's guilt or not. You understand that, do you not?
Yes, and that's why, again, I understand the process is if the committee wanted to charge me, they'd go to the House, get a resolution passed authorizing the committee to proceed.
Right, and you would be charged, you would be tried by the Senate with the Chief Justice sitting, and you would receive due process on the Senate side. To say that there's no due process.
My understanding is that that's not true. If you look at how this committee has conducted impeachment proceedings historically, the committee has held hearings. There have been witnesses. There have been the right to cross-examination.
I understand that, but in a charging decision, what the committee's history is one thing, but in a charging decision, the level of due process is based on the judgment of the individual or group charging, not the trial. The trial has a whole different level of due process than the charging decision. For somebody to say that you've received no due process when you're testifying here and you've testified in OGR is just not true.
Well, obviously, there are grand jury proceedings where, in fact, the charge is presented to a grand jury that decides whether there's evidence.
And the defendant has a right in a grand jury proceeding to be present?
My understanding of the process is historically the way the House has dealt with impeachment and where this committee has dealt with impeachment is the committee has had a set of preliminary hearings. The committee makes a resolution to the House that the House passes authorizing the committee to proceed with a full investigation, set of hearings, and investigation, and then the committee comes back to the floor of the House with a recommendation, which would be the charge. The charge is not made directly to the House floor. The charge comes in response to the Judiciary Committee having been authorized to start an investigation, holding the investigation, presenting witnesses, and then going back to the floor.
We disagree. I want to move on.
Well, that's fine. Okay.
You are familiar, I take it, with Title 44 United States Code, Section 3103, which deals with retention of records. And the people that work for you are familiar with this also, are you not?
I'm not familiar with the particular statutory issue.
The head of each federal agency, would you agree with me that you're the head of a federal agency?
I certainly am.
Okay. Shall make and preserve records containing adequate and proper documentation. You have a duty to preserve records that have documentation. Is that your understanding according to the archives?
According to the archives.
Okay. And those records may contain essential transactions of the agency. So that's the type of records that you have to maintain are the essential transactions of the agency.
Those are the official records, right.
And you understand that Lois Lerner's emails were essential transactions of the agency.
Not all of her emails, but a chunk of them were, surely. Some emails back and forth are not official records.
Okay, but her emails were important to Congress to determine which were essential and which were not essential. Nobody went through the emails before they were destroyed in West Virginia to determine what was essential and what was not essential.
Exactly. That the erasure should not have happened. It should,
so would you agree with me? That's the statute. I've just read you the elements of the statute. Would you agree with me that as the head of the federal agency that you violated that statute?
No, actually, I think, as you know, to violate a criminal statute, you have to intend to violate that statute. Nobody in the IRS intended to violate any of the statutes. Nobody in the IRS intended to obstruct.
And this is not a criminal statute, sir. This is not a criminal statute. There is no criminal penalty associated with it. This is the statute that defines what records need to be archived and the duties of the head of the agency. Would you agree with me that you violated those three elements as I described them to you?
No, I don't. Again, I think you violate it when you consciously decide, did we do it appropriately? Was it perfect? The answer is no. We've had an ongoing process with the National Archives about, we have an antiquated system about making sure that we're capturing official documents and official records.
But you have now filibustered me out of time. I can't ask you. But there are strict liability crimes. There are other crimes where you don't need to have the intent. I would yield to the chairman.
Without objection, the gentleman is recognized for an additional minute if he would yield to the gentleman from Ohio. Mr. Jordan.
Yes.
I thank the gentleman for yielding. Mr. Koskinen, these two guys down in Martinsburg, the midnight shift guys, were they employees of the IRS, or were they contracted to work for the IRS, to do work for the IRS?
They're GS4 employees of the IRS.
They're employees of the IRS. About 90,000 people work for the IRS. Is that accurate?
There were 90,000. We're down to 80,000.
Okay, 80,000 people. Of those 80,000, how many other people in that 80,000 work the midnight shift?
I have no idea.
I mean, is that common? When I think about government employees, I don't really associate, other than our military working around the clock, I don't really associate folks in government employment working the midnight shift.
We have a lot of employees working midnight shifts. We have during filing season, regular, our systems have to be up and running 24 hours a day.
Okay, all right. Mr. Chairman, I yield back.
Would the gentleman yield to me? I thank the gentleman for yielding. I want to follow up on that. You testified today that you wanted 2 months, you waited 2 months after finding out that the backup media was recycled before you informed Congress,
That's not correct.
What is correct?
What is correct is I waited 2 months after I learned of Lois Lerner's hard drive crash. I didn't learn about the erasure of the tapes until 2015, long after these hearings.
Okay,
there are two sets of issues. One is Lois Lerner's hard drive crash in 2011. The other is the erasure in Martinsburg, which nobody knew until the IG reported it in 2015. So what I waited for was I had advised there had been a hard drive crash. What I did was I said we need to then look at everybody who communicated with Ms. Lerner in that time to see how many of those emails we can capture. And that's how we captured 24,000 emails from that time period. As I've said, in retrospect, there was no hearing in between times, but in retrospect, I should have actually advised the Congress while we were doing that search.
All right. Thank you very much. This concludes today's hearing. Commissioner, you have given us a lot of your time. We thank you for attending. I want to point out to you that without objection, all members will have 5 legislative days to submit additional written questions to you or additional materials for the record. And we would ask that you respond to those, and I think it will be in your interest to respond to those written questions promptly.
We'll get to them as quickly as we can.
Thank you. And with that, the hearing's adjourned.